This video is for educational purposes only and does not constitute legal advice. Some content was created with AI. All names and events are fictitious. Please consult a qualified attorney for advice on your specific situation.
Ms. Harper, you have been served.
What is this?
If you've just been served with a lawsuit, don't panic. Most people don't actually lose in court because they were wrong. They lose by default simply because they didn't know what to do next. In this video, I'll walk you through the key steps to defending yourself clearly, simply and step by step, and if you can't afford a lawyer. In any lawsuit, deadlines are strict if you don't respond within 20 to 30 days in most cases. The court can enter a default judgment, which means you automatically lose without even telling your side of the story.
Our rate is $500 per hour. Unfortunately, I cannot afford that.
Hiring a lawyer usually takes care of these rules, but when you can't afford one, you have to act as your own lawyer. That means knowing the rules of civil procedure, understanding deadlines, and planning ahead. Doing nothing is the worst mistake you can make. So the very first step is to learn how to respond and to mark every single deadline on your calendar. The first thing you need to do is carefully read the documents you were served with, the summons and the complaint. The summons tells you how long you have to respond, which court you're in, and your case number. The complaint explains who is suing you and why. Once you've read these, you need to decide how to respond. In most places, you have two main options. First option, filing an answer. This is the simplest way you admit or deny the allegations and raise any defenses you may have. Second option, filing a motion to dismiss. This is more advanced. It asks the judge to throw out the case at the very beginning, but it requires solid legal arguments and supporting law. If you don't have a strong legal basis, filing a motion to dismiss can waste time and be denied. In that case, it's usually better to file a straightforward answer. Subscribe and like to stay connected. We need your support so we can keep creating new content on litigation.
Welcome back to Legal Insights Radio. Today, we have Professor Michael Reynolds with us to talk about civil litigation, especially how someone can defend themselves if they're facing a lawsuit without a lawyer. Welcome, Professor.
Thank you, Sarah. It's a pleasure to be here.
Let's start with the basics. What are the typical stages of a civil litigation case?
Civil litigation generally follows three main stages. First is the pleading stage. Here, the defendant responds to the complaint, usually by filing an answer or a motion to dismiss. If a motion to dismiss is filed, the judge decides whether the case should move forward or be dismissed at this early stage. If the case survives the pleading stage, it moves to discovery, where both parties exchange information, request documents, answer written questions called interrogatories, take depositions, and use subpoenas to gather evidence. Finally, if the case is not settled or dismissed, it proceeds to trial, where a judge or jury evaluates the evidence and renders a decision.
That makes sense. Let's talk more about discovery. What tools do litigants have during this stage?
Discovery is all about gathering evidence. Most jurisdictions allow parties to request documents from the other side, called requests for production, ask written questions, known as interrogatories, ask the other party to admit or deny certain facts or authenticate documents, take depositions of the opposing party or experts. The tools may vary slightly depending on the jurisdiction, but the principle is the same. Collect as much evidence as possible to support your claims or defenses.
I've heard that a lot of pro se litigants make mistakes because they don't follow court rules. Can you explain that?
Absolutely. Even experienced lawyers sometimes struggle with all the layers of court rules. A pro se litigant, someone representing themselves, must be familiar with several levels of rules. Civil Procedure Code, the fundamental laws governing litigation. Court rules. Each court often has its own set of rules about deadlines, document formatting, and filing procedures. Local rules. These are even more specific and may include instructions on notice requirements, submission formats, or scheduling motions. Judges' individual rules. Some judges publish their own procedures, like whether courtesy copies are required or how to set certain hearings. Many pro se litigants skip reading these local or individual judge rules, and as a result, their filings may be rejected or delayed.
That sounds challenging. How long does a civil case usually take from filing to trial?
It varies by jurisdiction. But on average, a civil case might take about 2 years from filing to trial, assuming it isn't dismissed earlier. For pro se litigants, a significant number of cases are dismissed before trial due to errors in pleadings or procedural mistakes.
Speaking of dismissals, what are the main grounds for dismissing a pro se case?
The most common reason is defects in the pleadings. This could mean missing key information, failing to respond properly, or submitting documents that don't comply with court rules. Procedural errors, missed deadlines, and improper formatting are also frequent causes for dismissal.
That's very helpful. So, for someone representing themselves, what would you say are the key strategies to avoid mistakes?
First, understand the rules. All layers: civil code, court rules, local rules, and judge-specific rules. Second, keep a strict calendar with all deadlines for filings, responses, and hearings. Third, document everything and double-check filings for compliance with formatting and notice requirements. Finally, if possible, seek guidance from a court self-help center or pro bono attorney for advice.
Are there any tools or tips to make discovery easier for someone without a lawyer?
Yes, even pro se litigants can organize discovery efficiently. Keep a checklist of what evidence you need. Track deadlines for responding to requests. Consider templates for interrogatories and document requests. If you're taking depositions or issuing subpoenas, read the rules carefully. Mistakes can invalidate the evidence.
That's great advice. One last question. Do you have any encouragement for listeners who are facing litigation without an attorney?
Absolutely. It's tough, but preparation is everything. Know the rules, meet deadlines, gather your evidence, and organize your case. Even without an attorney, a well-prepared person can present their case effectively. Remember, don't panic, know the rules, take action, get results.
Thank you so much, Professor Reynolds, for sharing your expertise. I'm sure our listeners will find this extremely helpful.
My pleasure, Sarah. Best of luck to everyone navigating the litigation process.
Once you know which option you'll use, start drafting your response. This takes time, so plan ahead. For your answer, go allegation by allegation. Either admit, deny, or say you don't have enough information. Then add your defenses like improper service, statute of limitations, or payment already made. This is where your calendar plan is crucial. Set mini deadlines for drafting, reviewing, and filing before the actual due date.
I'd like to file my answer to the complaint.
Next, you need to file your response with the court on time. Many courts now allow electronic filing, but not all. If you file electronically, make sure you receive a conformed copy. That means the clerk has officially accepted it. If you're filing on paper, keep a stamped copy for your records. And don't forget, you must also serve a copy of your response to the other side. This is a legal requirement in nearly every court.
Today is the initial conference hearing.
After both sides submit their initial papers, most courts hold an initial conference. This is where the judge sets deadlines for discovery, motions, and possibly trial. You'll get a scheduling order. Treat this like gold. Put every deadline into your calendar with reminders. Missing deadlines is one of the most common mistakes for self-represented defendants, and courts rarely forgive it. Discovery is the stage where both sides exchange evidence. You may receive requests to produce documents, answer questions called interrogatories, or admit or deny certain facts. You can also request information from the other side and sometimes from third parties using subpoenas. Depositions, live questioning under oath are powerful but complicated. We'll cover those in another video. Most lawsuits never reach trial and are settled or dismissed early. Settlement requires compromise and can save years of stress, time, and money, so it's wise to keep it on the table when trial outcomes are uncertain. In the U.S., roughly 67% of federal civil cases settle before trial, torts 82%, contracts employment 67%, with under 2% going to trial. In state courts, covering over 95% of cases, only about 3% reach trial, making settlement the main resolution.